squished over there. There, they got the Vegas thing.
There you go, guys.
There's Vegas.
Little room view.
Okay.
And that was the pool we were at all day long. It's good fun. I actually met somebody today from XRP crowd who had never been to Vegas before. And he was having a great day. It was amazing. And he was enjoying all the aspects of the whole town. So today, there's something else that I wanted to talk about that I didn't get in part one there. When you meet people with the same interest, it's almost amazing how many of us have the same desires and hopes and dreams for everything that we invest in. But it was even stronger today than I've ever seen it before. And I've been to I went to a Litecoin convention, I went to another convention, and there's something about this army that's just special, and I can't really put my finger on it. There were 20-year-old kids standing right next to 70-year-old men, and it was one-on-one, and they were on the same page with each other. And that's just so refreshing in today's world and today's society. And it didn't matter if you were red, blue, purple, or turquoise. It didn't matter. Everybody put all their political parts aside, and we were all here together. And it's been great. It's been a lot of fun. And I highly recommend all of you guys trying to find a way to come here next year. I know that's a lot of XRP that you could buy with the price of admission here and getting a room. So you do what's best for you financially, and you should do that. But if you really want to feel part of a family and part of a group and possibly create a history that's going to be with you the rest of your life, I highly recommend coming here and marketing and networking with other people. And I don't even mean if you have a channel or not. That doesn't even mean anything to me. It was just, we didn't even talk about my channel. We talked about us, and I got to finally meet everybody who watches my show. And I met 4 other YouTube people that I didn't even know they had a show. And there were many people, almost, I'd say 25% of the people that I met with today were like, hey, how do I start a channel? And what can I do? Do you think I'd be good at it? Do you think, do you think I have what it takes? As if I'm some sort of authority or something. Like, I don't have what it takes, and I'm doing it. So why doesn't everybody try it? But I was one guy in particular, okay, and he was from Chicago, perfectly well-spoken, an amazing guy, so versed on all of the things about crypto that he knew about finance and the rest of it, and the monetary system. And I was like, you mean you don't have a channel? Like, we need you. The people in crypto and the people in this world are making a difference with the youth going forward. He is an inner city Chicago guy who's living in a situation that is not easy, okay? Not an easy place to live. And he was so positive about mankind's future. And that's the beauty that you and I share about this kind of technology. And that's what I really love about our future, no matter your coin. You don't have to be an XRP person. You can be a Cardano, you can be a Bitcoin, you can be whatever it is. Okay, with that, hopefully this is a little better. I hope the sound's better. And
they say it is.
We won't get kicked out of our room this time, but
Sorry about that.
I hope.
A lot of this, I tried to fix the horizontal, vertical. I worked on it a little bit at the pool. And so if anybody's got some tips and tricks on that, please feel free to let us know how to fix this vertical, horizontal issue. Mine thing didn't work.
It's all good.
Okay.
We're running with it.
Yeah, we're learning with it. We're trying to be more consistent with the live. It's not that great. So I wanted to go, like I said, Jeremy left off about 4 months ago, as I could see, and I definitely want your questions about anything I can answer. Like I said, I'm not going to answer questions about predictions unless it's a legitimate, educated guess. So I want to let you guys know that from what I can see right now, is in terms of timing, everybody's interested in the timing. So when expert witnesses close, when the judge gives a deadline to exchange expert witnesses, so you tell me who your experts are and what your experts are planning to say at trial, and you and other side, you do the same at the same time. Like, there's no games. You can't, oh, I'm going to just file it late, and there's all kinds of penalties, all kinds of issues that go with that. So when the judge makes that call, that means the case is getting closer to trial, and one of those trials happens to be a motion for summary judgment. Sorry, it's a little dry. I'm teaching a little bit about this legal stuff that you may have learned from Jeremy as well, but a motion for summary judgment is a trial on paper. So everybody had to, it's kind of out of order, but it is a trial deadline, like a jury trial deadline. So once experts are closed, in general, they're closed. Okay, so that means that 6 months from now, one party isn't going to be able to say, oh, I forgot, I want to do this other expert witness. So we filed motions for summary judgment. Now, as I understand it, I don't know why a date hasn't been set, but the parties are supposed to be given a hearing to be able to come in after you file your papers, and then I respond to your papers like I explained last time, and then you respond to that response, and then there's the expert witness battle that they just had that I'm going to get into, because it's interesting as to what I've uncovered, and it's pretty thick, it's dense stuff, so I was going to break it down. I'm not going to do the whole thing in one setting. It can be like, I don't want to do a fire hose of information on it, but I would think there would be a hearing after all the paperwork has been filed. The judge would hear the arguments and motion for summary judgment. And here's a little bit about my impression about whether or not the judge would rule. And I think that we need to be very respectful of calling her Judge Torres and not Mrs. Torres or she this or she that, because it's not personal unless she's on the take. I don't know if she's there or she isn't, but it's not personal to you, me, or anybody else. She's the judge assigned. The court is called the court. She's supposed to be a neutral and fair arbiter, having no interest in whatever happens. And so that's just the court is going to decide this, whether somebody wins or loses. Sorry, I got lost in my train of thought, but my impression is the law, the constitutions, the civil code, the general principle of litigation is everybody gets their day in court. And a motion for summary judgment is not exactly that. Like, judges like to have things tried by a jury when a jury is been requested. So they're not favored. A motion for summary judgment is not a favored remedy. So to grant that would have to be very clear cut, winner, loser. Now, I have not, and Alan can have all of his stuff. I just told you I was going to stay neutral. Okay, I'm just looking at it from a bird's eye judge's view. And from what I've read so far from the experts is a triable issue of material fact, and that's a legal standard. A triable issue of material fact exists, and that's kind of what I gleaned from this. The judge has a lot of stuff riddled through here, and it is verbiage. It's like, well, we'll let the jury decide that. Okay, SEC, okay, Ripple, so I'm not going to deny or I'm not going to grant your motion on this expert. We're going to let the jury decide that. We're going to let the jury decide this. We're going to leave. And so that's why I'm giving you that impression that she's going to err on the side of caution and go with the public policy of, no, we prefer to have these tried by your peers, however that may be in federal court.
So what would happen in that case?
In terms, she denies both motions, so SEC filed a piece of paper, and I'm being very cute about it, I don't mean to be cute, hundreds of pages, moving for summary judgment. We want you to rule as a matter of law, Judge, that we win, okay? They don't get their day in court in front of a jury, they being Ripple. And Ripple filed their own motion for summary judgment saying, we judge as a matter of law, we win, and at the SEC shouldn't get their day in court, okay? And I just don't, my bet would be the judge would find that a disfavored remedy for public policy reasons. She wouldn't say that on paper, but that's just the way it is. Nobody knows whether this judge owns digital assets in some form.
No, we don't know that.
And anyway, and like I said, I don't know what kind of, this person said XRP, unadulterated evidence. Like I said, this is the country we live in. I can't exclude those things, but I can't necessarily say that about this judge. I don't know.
So let's get back. Let's say that she does want it to go to jury because she doesn't want to be the end-all be-all for all crypto decision. Okay, she says it's got to go to trial because neither side is so perfect in their presentation that I can rule. How long would that take?
How long would what take?
She can't decide either way, so she wants it to go to a jury.
She wants it to go to jury trial. I don't know. That's what I was saying about the hearing. Why isn't there a hearing date being set? So the parties get to argue, and then she makes a ruling after that, and then after that, the trial would be set. Now that would all depend on how many courtrooms are available for her, how many trials she has ahead of them, and all that stuff. Jody says he or she is, I'm making it more confusing. So please, if it is confusing, we're just sort of shooting from the hip here, please ask specifics about what's confusing, and that way maybe we can just be more clear. Sorry, we are kind of jumping into this a little bit off the seat of our pants, Jody, so please feel free to find out. So what I wanted to do is take you, I'm taking you to where Pacer shows the cases at today. Today, as of about 2 weeks ago or so, March, time flies sometimes. So as of March, the parties had all exchanged their witnesses, who the witnesses were going to be, expert witnesses, and what they plan to advance on behalf of their prospective party. So either SEC or Ripple.
Yeah.
Okay.
That's where Jeremy left it.
Okay, that's where Jeremy left it 4 months ago, saying, okay, summary judgment's filed.
Yeah.
By March, we're going to have a judgment, and this is what sort of, he gave some predictions at the end to be cute, and that was fine. That was fine. And he was great at making things clear. But I'm going to try and do that. I really am. I wanted to go through the order first, and then like Alan has some great questions, and that's great to jump. He can jump in as a layperson as well. What I plan to do as well is go through the comments after. So next Friday, when we do the next half of this, I'll go through and see what I can answer or I'm willing to answer, because like I said, I don't want to make predictions.
This is just going to be, just so you guys know who are tuning into my typical show, I think we're in a place on this legal case that a lot of us are just standing around going, what's going on? And as much as Deaton is helping us out, he's also really on one side of this, Ripple. And he's really fighting for Ripple, and that's what we want. But there's a lot of, we need an objective view. And I thought Elizabeth can be that, because she really, although she is invested, clearly, through her marriage, she's invested into a lot of XRP. But she's also somebody who's able to take it to a one-on-one basis, new fresh eyes from March forward, and stay with it every week. And I thought maybe once a week show would really help all of us try and understand where the case is today and going forward, because there's a big giant, which is she's explaining to you the best she can, to you and I, the lay people, that this thing could go on for some time. We're not at the finish line, possibly. It is possible that we are, but it's not likely.
But
Yeah.
it's definitely an objective marker is the judge said deadlines for experts is January. And typically you designate experts like that after the parties have completed discovery. So then the only thing left to do, well, not the only thing, I should never use that word only. The next thing to do is get depositions of those experts. So when SEC says, I have this expert, this guy, so-and-so, PhD, blah, 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 that's going to say this and that, I, Ripple, get to go, okay, that's fine. Sit down and I want to talk to him on a deposition, a sworn deposition, which is question and answer. I want to dig into what he knows, and then I want to depose the next expert you said, and the next one, and the next one. So that typically is what happens in a civil case, and I'm pretty sure it's similar in a federal. And if you really want to get into those nitty-gritties, I'm happy to do that, because I can look up federal rules of civil procedure and just refresh my memory.
So if you guys are getting some information on this and you like this, live stream, I'm going to do normal shows, my normal show more with some live stream. But Elizabeth is thinking about helping us understand this case better for all of us. One day a week, she's going to read the material that has come out over the week and your questions and answer those the following week. And this is kind of what we're trying to do to try and help people who are really confused about this whole legal process, because there's nothing simple about a legal process. Attorneys, every attorney, you can fill a room with 50 attorneys and there's 50 opinions as to what is law. And it's that confusing sometimes. Trust me, I'm married to one, and it's crazy sometimes how they see things completely different than you and I do, or the way the media portrays a case, or who's winning or who's losing. So I think she's going to be a great deal of help for us. This is just going to be something that we do once a week. It just happened to fall on the fact that we're in Vegas and we're at the show, and we just thought it'd be a great time to present more of this.
I may or may not. Like I tell my clients, take what you need and leave the rest. If this isn't something that's up your alley, it's too dry, it's just not enough definitive black and white, just skip it. Just skip it. Alan's got all kinds of great content that's coming. Lisa, we barely got started, so.
Yeah. And by the way, if there are questions that you want me to ask Elizabeth, from your point of view, that'd be great too. I hope you guys are getting something from this, because when I sit down and I talk to my wife about these things, I gain so much. And I think you guys could be learning with me, because I can't explain it to you the way she can. I just can't.
Okay. And then I'm going to stop getting distracted from the comments, but M. Evans, that's the thing, like that bright line, actual latest time. There's no such thing right at this point. Sorry, there just isn't. I looked, I combed through it. The parties still have lots of stuff to do to prepare. And like I said, is she going to bring the hammer down and say, SEC, you win. Your motions are all granted. And Ripple, you lose. Maybe. I mean, she could do that. And then Ripple's going to appeal that. But I think it's going to a jury trial, but maybe, I don't know.
What are the odds of a jury trial, in your opinion?
No, I don't have that.
No, I tried, guys. I did.
Okay.
I did try.
No,
you saw me.
The odds are not there. Just like I said, just the presumption of we like to go and have jury trials. So let's start with what I wanted to talk about was the order. This is an order from the judge that I pulled off the internet. Jeremy had a lot more fancy programming. I just got the old lady stuff here. I pulled this off the docket, the official Federal Register of Actions. Okay, so this is an order. SEC said these are my experts. Ripple said these are my experts. The then SEC said, Ripple, your experts, Judge Ripple's experts should not be allowed to testify because of this, this, and this. And Ripple said, Judge SEC's experts should not be allowed to testify or give you evidence because of this, this, and this. I'm going to go through, I'm going from the sort of the, when we were kids, we used to read the last chapter of the mystery novel first. I'm sort of doing that because we're so 4 months behind of what's been happening. So we are there. Anybody who's not happy with the presentation, you know, like I said, just don't tune into this. Wait for the next show from Alan.
Friday night, you guys can find
Friday
something else
night,
to
we've
do,
been at the
right?
pool and everything else.
Yeah.
So, order. Number one, which is what I wanted to do. I'm not going to give you the background because I am going to assume a lot of you have that background. If you don't have the background and that's something you want me to cover because you haven't been privy to Jeremy's videos,
We're 2 years in. I don't think we need to go backwards, really.
so I'm not
Yeah.
going to do that. But if
Yeah.
there are a lot of people that aren't
Let's go today forward.
familiar, then let's do that. Now, expert number one, the SEC offered the testimony of expert number one, who was the founder and managing director of an investment partnership which was originally primarily focused on making investments in the digital asset space. That's just his experience. That's what makes him qualified. Interesting, and maybe
That could be me for
we
all.
want to think about this is, why did the judge allow SEC to redact the names of their expert witnesses, and then Ripple didn't ask to have that happen? So the SEC's experts are secret, who they are, and Ripple's are not secret, okay? So I found that to be interesting.
And that's not very common.
I don't know about that. I don't know about that. I have never examined every million lawsuit out there, but I found that to be interesting. Typically, I've never done that in a civil case. First, so the expert number one, and that's how the judge called them. That was her name for them, since she was redacting, sealing under seal their names. Opined that based on XRP's design features and Ripple's public statements, quote, a reasonable XRP purchaser would have had an expectation of future profit derived from the efforts of Ripple, end quote. And I'm digesting of the most salient points from this order, okay? It's a 57-page order. Nobody's interested in 57 pages of legal garbledygook, right? So the judge, so then from expert number one, and I kind of want you guys to come to form your own opinions, give you information, you can form your own opinions about some of this stuff. And then this is what I found interesting. Oh, second, the defendants argue, Ripple, that the expert number one's opinion as to what a reasonable XRP purchaser believed should be excluded because he lacks reliable methodology to support his opinion. And I believe, if I remember correctly, down the line that the judge agreed with Ripple on that. Then,
And that makes sense.
I want to scan, so I don't want you to read all this. Provides no justification for the importance of those 6 factors besides his experience as an investor in digital assets. So I believe she agreed with all of that.
Because no matter anybody's experience in any field, it's still an opinion he's making.
So there, she's saying that she knows what we feel, we as investors or whoever invested. So he never talked to us, and that's what she criticized them for.
It's his opinion. He thinks it's a security.
So,
Okay.
motion to preclude expert one from testifying as to his first opinion about the perceptions of reasonable XRP purchaser is granted. And actually, I think she further defines that as not a personal person who bought a few Ripple, but maybe some, or XRP, sorry, I don't want to get confused. XRP different from a commercial one, but we'll get into that in a minute. Expert, So she granted that, but she is allowing expert number one to testify as to the remainder of his opinions and his rebuttal opinions. Okay, so his rebuttal is back here. Sorry about that. I'll have to get back to you on that because I don't want to hold things up. So I want to go to expert number two, and then if you want me to dig more out on that, I will, because I skipped that, and the lighting is a little bit rough in here, and my glasses are not great. Expert number two is another redacted expert, a securities consultant and former senior vice president of regulation and controls for the NASDAQ stock exchange. Okay, and then
he clearly has no bias.
Well, no, all of these experts, even Ripple's experts, are all biased.
Right.
They're paid to give opinions that support either SEC's case or Ripple's case on both sides. So again, I'm just adding the flavor of objectivity. So when we don't say, oh, well, SEC's got all these biased witnesses, like, so does Ripple, trust me. They have their own. So expert number two, the SEC is presenting them to support their case in the following way. Main topics: general registration and disclosure requirements for the offers and sales of securities under the Securities Act. 2, the general procedure for engaging in an initial public offering of securities, the costs typically incurred and the resources typically expended when companies raise money for an IPO. 3, how the SEC has historically brought actions against novel or innovative investment products, including digital assets, and how market participation could have sought guidance on how the SEC would apply securities laws to digital assets, and 4, specific types of material information that Ripple would have customarily disclosed had it registered its XRP offerings.
That is so vague and so not even relevant to the whole situation. First of all, he's talking about an IPO. They did not have an IPO. He's also referring to Ripple as creating XRP. Ripple did not create XRP. XRP existed before Ripple was involved with XRP. So he's saying that, oh, they launched this. That's what I got from that.
Gary Glisner, I thought the only thing she has to determine is it a security or not, regulation clarity. So as I understand from reading this, it's not a security has a definition, and then that definition has definitions. And there's all this evidence that goes into describing all of that, exceptions, affirmative defenses.
The Howey test.
Beyond the Howey test.
Yeah.
Has exceptions, and then it has elements, 4 elements, and then Ripple can bring in an affirmative defense completely separate from that.
Yeah.
So this is what the parties have put at issue with respect to these experts in a way.
But I'm with you, brother. We think, oh, well, it's just one question, swing the gavel and make a rule. Nothing in law is like that. It's just crazy. The whole thing is so absurd sometimes.
And I wanted to that's why I kind of wanted to present some of this more nuanced stuff, because we like to simplify things in our human brains. We like to have it just one thing, one black and white thing. So here, the judge says here, expert number 2's testimony is relevant because it will assist the trier of fact. That's, remember at the beginning of the video I said, she uses that a lot. Who will likely be unfamiliar with customary practices and requirements in the securities industry, meaning the jury.
Mm-hmm.
You're gonna have 6 people on there from the military or wherever they're gonna get these people.
They don't know a lot about securities. Yeah.
So to understand the nature of the SEC's charges, they're calling them charges, that's fine, and the impact of defendants not registering their offers and sales of XRP. Interesting language by the judge. She didn't say security. She said she's calling them their offers and sales of XRP. Further, expert number 2, I'm waiting, Alan's breathing sigh, heavy, so.
It's that statement is so frustrating to me because Ripple tried to ask the SEC, what is it you want? So many times, 6 years? And they didn't reply. So like she's implied, the judge is asking now, well, why didn't you reply? Why didn't you know all these things? Well, the SEC never told them what they needed to do to go public. Anyway,
Okay.
it's very frustrating.
Expert number 2.
And it sounds as if the judge has already decided that.
No, she hasn't decided that.
Well, her statement says she's acknowledged the fact that they didn't comply with the SEC.
No, she didn't say that.
Well,
He said the SEC's allegations and the impact of defendants not registering their offers and sales. The SEC's allegations. She's just
True.
framing it in terms of the
True.
SEC's allegations. Back to the objectivity. I'm trying to take the emotion out of it. So then the further, trying to get a little bit light here. Further, the judge speaking here, expert number 2's testimony about industry norms and practices and how defendants' actions deviated from such norms and practices may be relevant to the fact finder's assessment of Garlinghouse's and Larson's knowledge or reckless disregard for whether Ripple's scheme violated Section 5. Would you?
they went over that at least a week in court, and
I'm struggling with the light.
that was more than that. It was weeks.
Okay.
And that was very frustrating to follow at the time because, again, what's frustrating to me in this whole case is XRP was created before Ripple was even involved in it. And they're claiming that Ripple created this product to deceive everybody. Well, the product was already created. He could already owned XRP. Anyway, it's very
fine.
difficult.
Alan's editorials are not mine.
My editorial.
That's his, and that's I'm trying to give you guys the unemotional, dry, boring,
Yeah.
unfulfilling, lack of fulfillment. Then, so the judge gave an example. The court rejects defendant's argument that expert number 2 lacked, quote, facts, data, or relevant experience to support his opinion about how market participants may seek regulatory clarity. That was one of the complaints by Ripple to try and throw this expert out. And expert number 2 outlines how a market participant may request a, quote, no action letter from SEC staff, and to support his opinion, he cites online resources and his regulatory experience. And after all of these statements, she puts whatever evidence that she used to make that finding, okay? Last, defendants argue that the court should exclude expert number 2's opinion as to, quote, important disclosures that would have been, quote, material to investors with respect to Ripple and XRP, end quote. Expert number 2's report at page 28. I'm citing the citation. I'm sorry about that. That's really too dry there. Here, the court agrees. Expert number 2. So the court she's agreeing with Ripple. Okay. Expert number 2's opinions as to the materiality of important disclosures is a legal conclusion that would usurp the, quote, role of the jury in applying the law to the facts before it, end quote. Again,
Bringing up the jury.
That trier of fact mentioned. Does that mean anything at all? No, and that's a typical verbiage, but she keeps going back to that. She's saying, that's not for me to decide. That's for a jury to decide.
Mm-hmm.
Now, whether she's going to be the jury, the trier of fact, I don't know that yet. Only because I haven't researched it. I just don't want to make it. I haven't looked at the complaint. Nor does expert number 2 conduct an assessment based on the, quote, total mix of information available. Therefore, the court precludes expert number 2 from testifying as to the materiality of Ripple's potential disclosures. And then, so her final ruling on expert number 2 is expert number 2 is precluded from testifying as to his fourth opinion about the materiality of Ripple's potential disclosures. but granted. So Ripple wins that portion, and then Ripple loses from the other one. That expert number 2 will be allowed to testify as the remainder of the expert, the opinions offered, and that was the list of 4 that I gave you at the beginning. And if you need any recaps of this, we can all do that. We can take our time, we can repeat it all. It's not something that needs to be one and done, or you can go back and listen to it again. And I'm trying to figure out how to put those little timestamps so that maybe I can timestamp stuff, and if you did want to go back and listen to it again, I could put the timestamps in going expert 1, expert 2, and something like that might be helpful as well. Expert number 3, the SEC offered the testimony of a professor of finance and the founder, owner, and president of an expert consulting firm. Again, there's a bunch of qualifications given and so on, and if you're interested in that, I can do that. His academic research focuses on digital assets and has been extensively featured in a variety of media outlets. I highlighted that as part of his qualifications. I don't know what media outlets he's talking about. But here's expert number 3's opinions. 1, at specific times, defendants directed GSR, a digital asset trading firm, to buy XRP in a manner consistent with pushing XRP's price upward or providing a price floor to stabilize XRP's price. And 2, defendants sold XRP in a manner designed to minimize downward pressure on XRP's price and employed trading strategies to protect XRP's price. And then finally, XRP is going to further opine that defendants, 1, restricted sales of XRP to mitigate selling pressure and protect XRP's price from falling. 2, were incentivized to influence XRP's price. And 3, relied on XRP sales to supplement a funding gap, sorry, that was my glasses. And 4, used XRP in a manner similar to how companies use stock. With respect to XRP, or SEC's expert number 3, defendants seek to exclude the SEC number 3's testimony on the grounds that his opinion lacks any reliable methodology and is irrelevant and unduly prejudicial. Now, I wanted to talk to you about this unduly prejudicial language. When a party relies on unduly prejudicial language, it kind of is contrary to saying it's not relevant. It's saying it's going to hurt them. And there's lots of stuff that hurts lots of cases. I mean, I ran a red light, and at the scene of the crime, I say, "Oh, sorry, officer, I ran that red light. Ugh, sorry about that." And then in my deposition, I go, "I never said that. I never ran a red light. That's nonsense. That officer's lying," and all this stuff. Of course, I want to preclude my first statement, and then somebody comes, "That's so prejudicial," but that's true. So I don't know that's just what I know from practicing law, is that whenever we use that unduly prejudicial, it's going to be, the jury's going to be so inflamed when they hear all this stuff that they're just going to rule for SEC, and so we want to keep it out. And like photographs at a gruesome murder scene, they're just going to ignore all the other evidence. Was it even the defendant? Was he there? Did he make statements? They're just going to look at the photos and go, just find the guy guilty. It's an awful crime.
Sensationalize him.
Yeah.
Yeah.
So the big expert here for SEC, the court finds that expert number 3 reliably explains his selection criteria and so on. They only looked at a small set of trades over a few days, and that what she's doing is, cut out there, sorry. So the judge is saying that she's denying Ripple's motion to preclude this expert as unduly prejudicial, and instead is telling Ripple to address it during trial by cross-examining them on him or her on the limited sample, well, she said his actually, limited sample and failure to consider other data. And it's an issue that goes to weight, not admissibility. So she's not gonna throw him out. She's just gonna say, Ripple, get your lawyer up there and let him cross-examine and present and show the jury that they shouldn't rely on his testimony instead, because his methodology is flawed. So, I'm getting distracted from the comments.
Okay, what are the comments? Or what do we have there? So at this point, you've gone through 3 witnesses there, right? And
Yes,
3
I'm
experts.
not done with 3 yet.
Okay.
She's saying the court agrees XRP's methodology is reliable and properly applied, and a lot of hyper-technical stuff on why. And then this was a big expert, they tried to get rid of this expert really hard, meaning Ripple. The court rejected defendant's argument that expert number 3's opinions exceed the limits of its methodology. Again, they failed on that. They really did try hard. But she said they may question expert number 3 at trial about the absence of a causation analysis in his testimony, but expert number 3's opinions do not exceed the limits of his methodology. Again, they really tried hard to get rid of him on the methods by which he came to his so-called opinions.
So, okay, she keeps bringing up trial. Does that imply that she wants to take it to a trial, jury trial, to you? Or no? Why would she keep using that verbiage?
Well, because she's saying I'm not going to throw him out. She's not necessarily saying that, but it was giving me that impression, like that's kind of the policy, that's kind of the philosophy of things, is not to win or lose a trial where you have a right to have a jury of your peers decide it on pieces of paper. And I'm being flip when I say that.
They've talked about taking this to the Supreme Court. Would that would only happen after a jury trial, correct? Or could it happen?
What would happen?
They keep talking about it could go to a Supreme Court. That would be after a jury trial.
Typically, if you lose, if SEC loses the motion for summary judgment and Ripple loses, so they both lose, the judge just says, let's go to trial. You need to have a trial. Okay. Then whoever wins or loses that can appeal the denial of his or her respective motion for summary judgment, typically. Now, sometimes there's an extraordinary measure that can be made to come in and ask a trial, an appellate court, to take a look at the judge's ruling on a motion for summary judgment. But again, appellate courts don't like to do that. They like to just have a trial.
So then they would kick it up to a higher court at that point.
Later. So then from the trial court it goes to, I think it goes to the Ninth Circuit, and then from the Ninth Circuit it would go to the Supreme Court. Okay.
Right.
So
we are personally going through that in our own household in a case that Elizabeth's been working on for many years.
I mean, I've been doing a state case for 10 years.
Yeah.
It's a little unusual, but federal cases, I think Jody back in several comments is just asked more about timing again. Federal cases take a long time. They have tons and tons and tons of backlogged cases that take 3 to 5 years because they have courtrooms, the judges have other things going, and this is a very big case. It's a huge case. So.
This is, so many of us, we have our emotions in XRP and our hearts on the line with this. But what most people don't understand, it's not just about your profitability. This is about the future of crypto in so many different ways. If they don't succeed in this case, you might as well just write off the US as far as being cooperative in the future, in my opinion, I'm just making my opinion, they're not going to cooperate with crypto companies going forward because this is this set precedents, in my opinion. Again, my opinion, layman guy, that they're going to be able to point to this case and say, well, you know, we don't, it falls under that ruling of this judge or that jury or whatever going forward.
Sorry, my mic was
Are
under
you
my
guys-
boot.
Is everybody enjoying this, or should we keep going, or is it, what do we think?
I'm going to go to the last SEC expert, which will be number 5. So I'm halfway through number 3. And if you guys don't like it, just tune out. I'm going to just finish it, and then we'll see what the consensus is.
Yeah.
If it's helpful. And this is just kind of a dry run on my part to see how information can be presented to you, or if you're just really more interested in, we're going to need a battery charge here. So that's another issue that we're going to have. So we're going to need a battery charge as well. We might have to unplug the microphones to plug the phone in.
Yeah, we're a long ways from the plug.
No, we're not. There's a plug right here.
Oh.
Yeah.
Alrighty. So hopefully the sound, I got this. Keep going, Elizabeth.
He said keep going. If there's one guy who wants to keep going, happy man, we're going to do it. An XRP, PP. Somebody, I can't see it because the battery's really low. Okay. Ooh, we really went down.
Hopefully you guys can hear us still.
Sound quality, sorry. Turn your phone or tablet sideways to... Yeah, tried that. And, ooh. Oh, that guy recommend... Oh, did that work? No, it went sideways. It didn't work. Sorry. I did take your suggestion, Chris. We're struggling with that. It didn't work. Sorry to make everybody dizzy. Okay, we're going to keep going. Expert number 3. It's a big... For some reason, this is a big deal. This went on for several pages, which was many more pages than the first 2. But Ripple contends that expert number 3's 4 opinions as to defendants' sales prices, practices, my apologies, incentives are not based on reliable methodologies. Back to that methodologies thing again. They kept harping on that, trying to get rid of this expert. So this is a damaging, sorry to be a Debbie Downer, this is a damaging expert for Ripple, and that's why they are going hard trying to get rid of this expert. So expert number 3, judge talking, not me, sufficiently explains how his economics and finance experiences forms a sufficient basis for each of his 4 opinions, cites financial theory and blah, blah, blah. Again, she's saying it's fine. His methodology is fine. His financial theories are fine. Go back to your cross-examination. His experience is fine. Sufficiently and reliable explains how his opinions on the sales practices and incentives arise out of his economic and financial experience and research. She says it's all fine. They kept trying. Last, the court speaking. The court rejects defendant's argument that expert number 3's opinions are irrelevant and unfairly prejudicial. Here's where I said this big one comes in. It's like, if I can't get you on that, then let's just do this last Hail Mary, last ditch attempt, saying it's going to make the trial so unfair that we just can't overcome it. And it's kind of a melodrama sometimes by lawyers just to try and get rid of some evidence, like autopsy photos. It's like, of course the jury is going to see the autopsy photos, and of course the jury is going to be prejudiced by them to some extent, but they're relevant. The jury wants to see them. So
Again, this is Ripple trying to keep this guy out.
Keep expert number 3, the guy about the sales practices, saying that Ripple was jacking up the price of manipulating the price.
Mm-hmm. You know, like Wall Street does every day.
That was my summary. I can go back to the precise language that the parties used on that. I'm using the word manipulation. The judge did not use the word manipulation.
They have a thing called the plunge protection team. What does that tell you?
Yeah. Expert number 3's testimony about defendants' incentives and actions to influence XRP's price is directly relevant to the fact finder's determination about whether purchasers of XRP reasonably expected profits derived from defendant's efforts, the last element of the Howey test for an investment contract. Okay, accordingly, defendant's motion to preclude number 3 from testifying is denied. Number 4. Now remember,
So she denied it.
right, that expert number 3 is coming in.
He's allowed, yeah.
I haven't even, you want the good news or the bad news? I'm giving you the bad news today. Next week, I'll come in with Ripple has 10 experts that they presented. So,
it's almost like picking a jury.
I could have gone with Ripple's today, but typically we start with the plaintiff and then we move to the defendant. That's how everything's presented in a court. I'm just doing it that way. So expert number 4, the SEC offers a testimony. So don't panic. Don't do anything. Do not sell or buy based on me just reading you a court document from what these parties are doing. And don't do that, okay?
Yeah. Not legal advice.
Not
or
financial
advice.
It's not meant to influence anything along that line. I'm really just reading a document to you.
And if you guys are enjoying this, hit like, because it does help to put it out there to other people that might really enjoy this kind of legal side of what's going on with the thing that we love.
Expert number 4.
And I really enjoy the comments. I just read them and they're really good. So thanks so much.
I do appreciate it.
Yeah. She works really hard on this kind of stuff. She's a really busy attorney, and she's taken the time out for us in the Ripple XRP community. And she's trying to clear some things up without being biased, which is really hard to do in the world we live in today.
Yeah,
so.
And Jody said, don't worry, we're not crying because we knew about these basically anyway. So that's good. Some may know, some may not. Some are just coming on board. Some are just getting up to speed. Yeah. I'm just getting up to speed. I looked at this, I was like, oh, this is very interesting to me. But I'm a geek that way on this stuff. So SEC offered the testimony of expert number 4, who holds a PhD in distributed systems and has 18 years of experience in computer science. Expert number 4's expertise is fault-tolerant distributed systems. Fault-tolerant distributed systems, okay, which is, quote, at the core of blockchain and decentralized systems. In his expert report, expert number 4 offers 3 opinions on behalf of SEC. The XRP ledger is not a, quote, decentralized system and is less decentralized than the Bitcoin and Ethereum blockchains.
Not relevant.
Yeah, I thought this is a bit off kilter here. Ripple's efforts are necessary to support the proper functioning of the XRP ledger. Ripple, quote, if Ripple, quote, walked away from its role with respect to the XRP ledger, serious risk to the XRP ledger's operation would arise. Like, when I was reading this too, I was thinking, who is SEC even trying to protect? Like, they're just trying to make work for themselves, is what I think.
Now, is his identity disclosed?
Nobody's identity. All SEC's experts were redacted.
So I was like, PhD, I think I kind of knew who that was, but maybe I don't. It's not who I thought.
So again, here comes the judge. Defendants may challenge expert number 4's opinion at trial on the ground that he ignored relevant factors or misapplied the factors he did consider, but disagreement over an expert's conclusions does not warrant exclusion. Whatever. Second, the court also rejects defendant's contention that expert number 4's second opinion on Ripple's efforts to correct operation of the ledger is unreliable. And this was interesting. You guys, all you crypto geeks, maybe understand this. The defendants argue that expert number 4 reviewed the improper version of the XRP ledger's software code, a version that was not in place at the time of any of the SEC's allegations.
Yeah.
So
most of us knew that. Put in the comments down below if you knew that. That was pretty obvious to me when you read that first paragraph.
Defendants do not challenge XRP's expert number 4's interpretation of the code, only that he analyzed the wrong code, and the court finds that expert 4's methodology for analyzing the code was reliable, and so on. And third, defendants wanted to get rid of expert number 4 because his third opinion, quote, if Ripple would disappear, serious risk to the correct operation of XRP ledger network may arise, and it was unreliable, no scientific methodology, blah,
And
blah,
he's
blah.
basing that on the time in which they only ran 21 nodes, and that was a time that I believe Ripple had over 50% of all XRP. I think that's what that's based on. Put down in the comments below if I'm wrong about that, but I'm pretty sure that's what he was implying. And how do you say that that's not a solid blockchain with 21 nodes? I mean, I've heard that argument before. I've heard it compared to Ethereum and Bitcoin in that same manner for that same reason. And again, it's not relevant. She said it wasn't relevant, right? The judge said that was not relevant.
No, she never said it was. She's saying this is relevant. She's not. Didn't challenge it on relevance. They challenged it on unreliable.
Okay.
Unreliable. Looked at the wrong code. Expert number 4 does not explain how his personal experience provides him with a sufficient basis for speculating about how others would behave. Without more, quote, generic appeals to an expert's experience are not a substitute for reliable principles and methods. So this is good, but defendant's argument that the relevance of expert number 4's opinions are substantially outweighed by the risks of confusion and prejudice to Ripple. Expert number 4's testimony is relevant to defendant's argument that the decentralization of the XRP ledger means that XRP cannot be a security. So again, they did try, obviously, to keep that expert out. And then, so the court speaking now, expert number 4 from testifying as to his third opinion about the risks to the XRP ledger that might materialize if Ripple, quote, walked away or disappeared is granted. Okay, so the third opinion about them walking away and that, somehow being really bad, they won that one. Ripple won that one. But defendant's motion to preclude expert number 4 from testifying as to the remainder of the opinions just mentioned, just the one that we just went through, is denied. So expert 4 is coming in. Except does that one walk-away issue. Expert number 5, finally, the SEC offers the testimony of expert 5, who holds a PhD in economics and is a principal consultant at a global economic consulting group, 15 years as an economist, and specialized in credit research and modeling. He, quote, conducted event studies to assess the impact of credit actions and announcements on corporate and sovereign costs of capital. I highlighted that. I thought that was kind of interesting. I don't know why, but so Ripple wanted to get rid of expert number 5. Oh, he also has a rebuttal report. And he conducted an event study of XRP's price movements over time in certain, quote, event windows after positive news events announced by Ripple. Oh, this was another interesting expert. Based on this analysis, expert 5 concludes that XRP's price increased after positive Ripple's announcements. Second, expert number 5 conducts an analysis comparing XRP's price to the prices of Bitcoin and Ethereum to conclude that the price movements of Bitcoin and Ethereum could only explain on average 40% of XRP's price movement. In his supplemental report, expert number 5 uses the same economic model from his initial report and calculates what XRP's prices would have been, quote, but for Ripple's positive news announcement. So this is kind of like along those lines of expert number three. And so defendants argue that, meaning Ripple, argue that number 5, event study methodology is flawed and should be, so that he should just be excluded outright. And
Let me take a second on that one. Okay, first of all, Elizabeth was a forex trader almost as long as I was. When you understand what trading means, the first thing you know about trading and charts and graphs, fundamentals or technical analysis, is you can't predict the future. In my opinion, what he just said there was he's saying, well, they had some positive news and therefore that they put it out deliberately to influence the price. That's what I got from that. And he's speculating completely because you don't know. We've all heard positive news. And we've also heard a lot of positive news with XRP, over 30 countries adopting it, and the price doesn't move. So he's saying, oh, well, it moved this time and they made it move, or he's speculating that time that it moved when Bitcoin didn't and Ethereum didn't, that Ripple did, or sorry, XRP did. He's saying, well, that was because of something they did. And that's what he's implying there. That's what I got from it as a layman. And
so the court is
the
saying
market's too big to move like that.
I know people rely on that stuff all the time, but
yeah.
So that was kind of strange. But the court cited the following law, which I thought was interesting, and that's the only reason I give you this super dry stuff, is because, so the court citing some law, quote, because, quote, a minor flaw in an expert's reasoning or a slight modification of an otherwise reliable method will not render an expert's opinion per se inadmissible. The court will only exclude expert 5's event study and the opinions arising from that study if any alleged flaws are, quote, large enough that expert 5 lacks, quote, good grounds for his conclusions. And so she cited a case there, and the case name doesn't matter. It's in the, if you really want to look at the case, I will give that case to you. The court declines to usurp the role of the trier of fact in determining the efficiency of the XRP market. Again, my language, not hers. She continues, quote, a question of fact and the reliability of an event study in assessing correlations in that market. Expert number 5 provides a methodological explanation for selecting positive news by separating Ripple news announcements into categories and excluding certain news events that he determined were repetitious or directionally uncertain. Again, I think she's going to get back to her cross-examination
Can't believe
thing.
she fell for that, but anyway.
Defendants' contentions about expert 5's over or under inclusion of data may be valid criticisms, but they speak to the weight of his testimony and not its admissibility, meaning take it up with the jury. Ripple, you expose the weakness in you expose him to be as unreliable and biased as you're going to do it with your $900 an hour lawyers or whatever they are. Okay. Third, defendants argue that there is, quote, too great an analytical gap between expert number 5's event study and his conclusion offered during his deposition. Oh, they've already had depositions. Okay, so very interesting. I didn't see that before. I just learned something myself. Deposition at 250 to 251.
Okay, I missed that. What does that mean to you?
Well, remember at the beginning of the video, I said that you designate your experts and then you do depositions. And they've already done depositions. I thought they were going to, they've already done depositions. Of course they have. They want the depositions for the motion for summary judgment. So they've wrapped up a big part of the discovery of the case. So when discovery closes, then the court's starting to think about going to trial. So once the court rules on this motion for summary judgment, she's going to set this for trial. Now, when do federal courts set things for trial? This is a long trial. This is not going to be a couple days trial. So to try and space a trial like that in somewhere will be tricky. She's going to have to block out a large amount of time. You got like,
You're saying if she doesn't accept the challenge of ruling on it.
she's going to accept the challenge. She's going to deny or grant the motion. She's not just going to punt and say, I'm not going to decide them at all. She'll just, so if they both get denied, we're going to trial. The trial will be scheduled at some point. And I just don't understand the backlogs of federal court cases right now.
See, guys, this is why I've brought her on. This is a perspective that you and I don't get. We hear kind of a one-sided information of this. She's implying that this is not going to be a win or lose case in a week or a month.
But we are a lot closer. We are a lot closer, but I use that word very loosely.
Yeah.
Closer meaning we're at the end stages, but whether or not we get to a trial this year, because like I said, this is a lengthy trial if it goes to a jury and it's not that she doesn't want to. If she denies because there's tribal issues of material, if there's one tribal issue material fact that needs a jury, it's going to go to jury trial. So,
and that's a perspective that I don't know how many of you have even heard that before. I mean, we don't talk about that kind of thing. That's why I don't talk about the legal case of XRP on my channel, because of statements like that she states is not a matter of fact. I mean, there's still a possibility of it could not go to trial, but I don't hear anybody talk about it possibly going to trial, which is really kind of annoying. Like, why hasn't anybody talked about that? I know we all have hopium and we all want it to be settled. We want to rule in our favor and the thing to go to $10 or $50 tomorrow. But I hate to disappoint everybody, but it doesn't sound like that's going to happen in a week or a month.
It's not going to happen in a week, but we're definitely at the end stages. We're definitely farther along than I understood before. I just saw that and I realized that's right. They wouldn't have made all these motions without the deposition testimony. So my bad on that. It's just been a little while since I did any kind of civil litigation. Without additional analysis, so the court said they are agreeing with defendants, surprise, surprise, that there is, quote, too great an analytical gap between Expert 5's event study and his conclusion offered during his deposition. And so that Ripple's announcements caused XRP's price to rise. The court agrees without additional analysis, controlling for confounding factors or an appeal to academic literature to support a determination of causation. Expert number 5's event study demonstrates at best correlation between the news announcements and XRP's price changes. His statement of causation is supported only by his ipse dixit, and I don't know if I'm saying that word right, dixit, it's Latin. Ipse dixit is a quote, he himself said it and is defined as something asserted but not proved, what we often see in the media about many issues going on in today's world.
Yeah.
So,
not a statement of fact.
So I just said, it's kind of like a fancy way of saying gaslighting, actually. So, finally, I'm going to wrap this up. I'm at the end of this now. The court finds that expert number 5's, quote, but for price methodology is reliable, however, and any flaws in his application of that methodology are not, quote, large enough that he lacks good grounds for his conclusions, end quote. Accordingly, defendant's motion to preclude expert 5 from testifying as to causation is granted, so a win for Ripple there, and defendant's motion to preclude number 5 from testifying as the opinions in the balance of his opinions are denied. So, and John Deacon talks about the trial all the time. Great. Clarity of secondary sakes not being securities. Okay.
Yeah.
So
John does. Actually, I met John by the poolside today. He was at the pool. Another reason why he should come next year.
Yeah. And anything, and Alan and I are just chatting and trying to get, people are always asking Alan about what's happening in the case, what happening in the case. If you can find the lawyer and ask him, go for it. But otherwise, I'm just trying to give a summary, like I said, just where Jeremy left off and just letting you know. So I'm at the end of SEC's experts. You see now affirmatively who won, who lost, those little, we call it in law, we used to see win or lose the battle, win or lose the war. So right now, Ripple won a few, lost. The Ripple or SEC won a few. The battle still, the war still has yet to be fought. Right. So I've got 10. Ripple has 10 experts that they presented to the judge at the SEC to get rid of them, basically. And so I'm thinking maybe it's so lengthy, but Alan and I are just sitting here chatting. It's our Saturday night after the pool, or Friday night. Yeah. I'll break them down 5 and 5. You let me know.
That was fun.
What you want to know? Like, there's some people that already know all of this stuff, and so
that's the thing about the Army is we've been through this a couple of years now, and we kind of know a lot of this stuff, but we have formed prejudice and we have formed opinions. And let's face facts. John Deaton has skin in the game, right? There's nothing more compelling than your attorney fighting for your case. I mean, they are really.
Northern Living is going to Senior Frogs. I don't know where that is.
But again, Frogs, it's right around the corner here.
The other thing is, because I'm kind of new to this, the more I read, the more impressions I get. Just like I was reading today and I noticed something. I was like, oh, okay, I noticed something, or I'm getting a feel for something, or something pops into my head just as my own impression is not meant as anything as like, why is SEC all, what is the experts that they present? Okay, great, they won some, they get all their experts in, but why waste all of our money? Do you know how much money these lawyers are getting for SEC and Ripple? A ton of money. A ton.
Ripple's over 100 million.
And think about SEC. They're spending even more. They have an unlimited budget. They can just print, and spend it. So imagine that. The only people winning here are the lawyers. And I am a lawyer. And that's it.
Yeah. And unfortunately, it's the world in which we live in today. That was the beautiful part of the original Constitution our forefathers said that lawyers should never be politicians. And that was until 1860, I believe, because of this bureaucracy and this red tape. And it's very frustrating because it's not a set law, and you and I live in a set law. If you did 6 miles an hour, you broke the law if it's a 65 mile an hour zone. We understand that. But there's nothing that black and white in law. Nothing. And the longer I'm married to an attorney, the more I realize that. And she even understands how frustrating that can all be because she's saddled with the same system. And it's so much speculation of law. It's just crazy. It's interpretation.
Yeah.
And it's for us, it's
But
tough.
I just want to emphasize, I really do want to emphasize, I started with the bad news. We're going to go to the good news for anybody that's new to the scene. And I know whoever Jody is, he or she is very up to speed on a lot of this stuff. And yeah, the redaction of the names, that was one of the things. Redacted for what? And SEC or Ripple's got all their names all over. What the hell is your problem? Like, SEC, I'm not biased. I just, because I might have my complaints about Ripple as well, but I do have the complaints about the lawyers. I mean, the lawyers are just getting fat over this thing.
And
So, and I'm not criticizing their lawyers. I'm just saying all the lawyers, they love this.
Yeah.
What do you think about, someone getting in an accident? Why do you think I stopped doing accident work? Someone gets injured in an accident. It's like, oh, good, juicy, I can make money. That's gross. I don't like that.
Yeah, it's tough. But but then again, the people that have been injured need somebody on their side.
And
So,
there's that argument.
yeah.
So you gotta
So somebody's going to Senior Frogs,
senior frogs. Living northern living.
Northern Living. You going to be there soon? We should wrap this up, guys.
Yeah, it's a
been
dog
long
and
enough.
pony show. It's a dog.
Yeah.
So thanks a lot, you guys, for tuning in, and thanks for all the likes and stuff.
Yeah.
And as
Really-
I go, hopefully it'll be less stilty and
Yeah.
choppy and everything like that.
I really wish you guys were here. And those of you who are, I'll see you guys tomorrow. I'm so excited about tomorrow. There's so much to learn. And John Deaton looked amazing. He was just like talking to everybody, walking around the pool, and it was really fun. And there's a surprise guest. I think I mentioned that in the first video. There is a surprise guest. A bunch of rumors flying around. Who knows? I took a couple of pictures that I'm going to post are going to be some of my thumbnails coming up soon. So there's some really fun stuff coming up, guys. So stay tuned. We love you all. And sorry about our voice and the long day around the pool. We wanted to show you the pool, but the sound was just terrible. And we'll be back soon. Do you have anything else, Elizabeth?
No, that's it. I just wanted to get us caught up to speed, and then if something new comes out, I'll probably jump on that instead of going back in time. But the experts are, to me, very, very fascinating.
And post your questions about today and those 5 witnesses for Elizabeth for next week, if you have any, other than just my layman terms or questions that I ask her here and there in between. Okay, guys, with that, I believe we are out.
Senior frogs, here we come.
Here we come.